they're not the most useful document unless you're hit by a car, thrown vehicle, and in your jacket pocket you have your directive to physicians. So that upon finding you laying in the street, they say, "Aha, here is the directive. Here's what we should do."
You don't walk around with your directive. I do. I'm such a hypochondriac. I think I could die at any time. I just have the directive right sewn into my clothing, in case.
Well, I didn't have a will until a couple years ago, so no, I'm the opposite of you. My affairs may or may not be in order.
All right. Well, so the physician's directive, living will, basically you're gonna write some stuff down on a piece of paper that tells the doctor what to do, whether to resuscitate you. But and I think we had this debate before. Do you think you need one if you have a medical power of attorney? Welcome to episode 133 of the Weekly Docket, a podcast by the Silberman Law Firm where we talk legal news and practical law. Today is July 31st, 2026. I'm Phil Silberman, owner of the firm, and I'm joined by Chris Hills, who's the firm's managing attorney. And Chris, we've got 3 questions we're going to answer today, all very practical questions, useful questions. Everything we talk about is useful and practical. Before we get started, all the kids are excited to go back to school and in full school going back to mode, right?
No, still not.
Hold off as long as you possibly can, because when that first week of school comes in Texas, they go back about August 10th, 15th, something like that. It's crazy. Like all the activities are just all in one week, and kick off the year, and dad's clubs and mom's, mahjonging goes intense, and the kids are Girl Scouting and football practicing and things like that. So anyway, that not something that I look forward to. All right, let's go ahead and talk a little bit about what's on our docket today. We're going to talk about the infamous living will. And then we'll discuss affidavits of heirship and how long they need to be on file. And then finally, rollback is not like Walmart's rollback prices, not the opposite, right? The opposite, much more painful, but we'll talk about those 3 things. So let's go ahead and get it kicked off with our first question, which is, what is a living will, also called a physician's directive? Chris, this is all you. Come on, tell it. What is it? We get this call all the time, and what do clients mean? What do people mean?
I don't know. I'm confused at this point. People like to just, with all due respect to people who may call and do this, but people like to add legal words to stuff. And so they say, I need a living trust, or I need a living will, or I need a deed of trust. No, you just need a deed. You don't need a deed of trust. They really love adding these extra legal words on there.
Well, they all have those things you mentioned. Some of them do have different meanings, but
no, they do. That's my point. They want to make it sound more complex. Instead of just saying I need a deed, right, they're like, wow, I want a deed of trust. Deed of trust sounds so much better, and I want to have trust in the person who will deed.
It's like, a marriage of trust, right? Like
right, yeah. I don't know. I want to, yeah, something like that. We can just make up legal terms. It just a living will or a living trust. I think you're right. I think when people say a living will, what they really mean is a directive to physicians. I've certainly done a handful of those. They're not the most useful document unless you're hit by a car, thrown vehicle, and in your jacket pocket you have your directive to physicians. So that upon finding you laying in the street, they say, aha, here is the directive. Here's what we should do.
You don't walk around with your directive. I do. I'm such a hypochondriac. I think I could die at any time. I just have the directive right sewn into my clothing, in case.
Well, I didn't have a will until a couple years ago, so no, I'm the opposite of you. My affairs may or may not be in order.
All right. Well, so the physician's directive, living will, basically you're going to write some stuff down on a piece of paper that tells the doctor what to do, whether to resuscitate you. Um, but and I think we had this debate before. Do you think you need one if you have a medical power of attorney?
Well, that's what I tell. I say, get a medical power of attorney, make it somebody that you trust, and make your wishes known to that person, and trust that they're going to carry out your wishes. And if there are tough decisions to be made, they're going to make those tough decisions, and that's going to be it. That's to me the most efficient, effective, peaceful, harmonious way of handling things, instead of, having family members fight over it, wondering if there's a directive to physicians, all this stuff. Just have a trusted family member. If you trust your spouse or your kid or your best friend.
Now, all family members may not want to make the best decision for you. You've heard this story before, but I'm going to tell it again for our listeners. My father-in-law, longtime doctor, and he had a patient having a heart attack, medical emergency heart attack in his waiting room. The front office person runs back to, Dr. Conrad, come quick. Someone's having a heart attack in the waiting room. And, my father-in-law goes out there and goes into doctor's mode and starts to resuscitate him. And the spouse, the wife, who's also in the waiting room, said, Dr. Conrad, you need to know that my husband said he never wanted to be resuscitated. And my father-in-law looks at him and looks at her and says, ma'am, it is way too early for that at this point. So you have to.
That doesn't mean we should prevent someone from. So, and there's a lot of misconception about that. And there's a lot of realist conception about that as well. Most people are just live in fear of being on a ventilator or a feeding tube for years and years and years. I think most people, in all the ones I've done, those people are saying, hey, don't do that. Don't, if my quality of life is going to be terrible, don't resuscitate me if I'm going to be brain dead. Don't leave me on a feeding tube. I'm probably in the minority. I'm probably one of the only people I know that sees opposite, but it's not so much about yourself always as it is about your family. Do you want your family not able to carry on? Do you want to be on a feeding tube for a year while your family is not able to move on? You don't really have any substantial likelihood of recovery.
Yeah, that's because you believe you could come back at any moment. Like you could, come out of the coma.
I believe the good Lord works miracles, and I believe modern medicine advances much quicker than we know. And I also just don't trust people in general, and I certainly don't trust doctors. As I've said, I don't trust all doctors, but I think there's cause for healthy suspicion on whether people might jump to conclusions sometimes. And that may not be all doctors. It may not be a majority. It may not be 10%. But I only get one life. I'm only here once. That's what I do.
Well, this is neither here nor there, mostly neither. One of my favorite movies, I'm embarrassed to say, I really did enjoy this movie. It's an embarrassing movie. I don't even know what the name of it, but it really resonated with me, as like a late 80s, 90s kid. It's a movie about a girl who's a cheerleader in the 90s, and they drop her and she goes into a coma, and then she comes out of it like when she's 40 years old, and she goes back to high school in the modern era like a 90s kid. Okay. That's the whole movie. So it worked out. Your theory worked out.
No, that I've seen.
I highly recommend it if you want something lighthearted to watch. But I'm very embarrassed that I'm going to get a lot of feedback, social media feedback, making fun of me about that movie. But decent little 90s nostalgia flick. 90s is back, by the way. A lot of nostalgia 90s business models out there right now. So.
And because of us, because everybody knows they can just sell to us now. They're like, hey, these 40 somethings love the 90s, so we can sell them anything from the 90s, and now they have money and they'll pay for it because now they're working adults in professional careers. We can sell them anything.
Yeah, very popular. All right, we got to move on to our next question. How long does an affidavit of heirship need to be on file to sell a property? Chris, start off with, give us the background on just what an affidavit of heirship is and what it's mostly used for in Texas in regards to real estate.
Well, an affidavit of heirship is a document that you prepare and you record in the deed records as prima facie evidence of the heirs of a person who is deceased, evidencing where their property has passed. Because under the estates code, title vests upon death. So the law is when you die, title to your property vests in either the beneficiary of your will, or the heirs of your estate. And so, the affidavit of heirship does not transfer title. It is a legal document showing evidence of the transfer. It's saying, hey, this person died without a will, therefore their property transferred on their death. And here are the people it transferred to. It is not signed by a judge. It is just signed and notarized by two disinterested witnesses. It's recorded in the real property records. Again, it's not an actual instrument of transfer, but it is something as public. You may rely on this. So if you're a purchaser, you may rely on it. Title company, you may rely on it in issuing an insurance policy because, this is just a way we made up that's efficient in demonstrating a way to get title from someone's estate to their heirs or to their beneficiaries.
Yeah, and let me just say that is well said. Excellent explanation. Let me break it down a little bit for maybe some of our listeners who spend most of their lives scrolling on social media with like 30-second attention spans. And I think it could best be said, or one way to say it is, it's a piece of paper that you file in the real property records that says who gets the property, who owns the property. And what Chris so adeptly did well was quote without knowing it, but quoting the Texas Estates Code section 203.001, which says it's prima facie evidence once recorded for 5 years is the period. 5 years, then the courts can legally presume, the statements are true. We record affidavits of heirship all the time, and they close deals much earlier than 5 years.
Once 5 years have passed, if nobody's filed the contrary affidavit and nobody's filed the determination of heirship, we're done. We don't need to go past that.
I've heard as short as 6 months, but got to at least be on file for a year before they'll rely on it. So
then that's rough. That means you got to sit with the property for at least a year. If you wait 6 months after someone dies, that means you're sitting for 18 months with the property. You can't do anything.
Yeah, you could always do a probate.
Those are far more expensive. I mean, affidavit of heirship, we charge $1,500, and any testate probate, we're charging between $5,000 and $10,000. That's quite different when you're talking about an $80,000 house that's not in good shape that these heirs don't want to carry for 6 months while we go through a probate. They want to just sell it to the investor who's going to give them bottom dollar, but they don't care. They're saying, make it your problem, not mine. They don't want to invest the money to deal with this headache.
Yeah, for sure. Well, and the takeaway there is affidavits are a very inexpensive way to pass title to property. And hopefully it's been over 6 months, been over a year. If not, you're probably looking at a full probate. But all right, final question for the show. What are rollback taxes in Texas? This is one you don't hear about very often, but this is probably our most boring question. It's a tax recapture method, okay? And it occurs when a property has benefited from a special tax exemption or tax valuation. Usually see them in agricultural exemption situations. So farmers have been using property for, farming, growing corn. Farmer sells to a tech company to do a data center, right? Well, that use is changing, and because the agricultural exemption is no longer going to be effective, the government gets to go back for 3 years and tax at the higher rate, recapture those taxes for the last 3 years. Are you familiar with that? Heard of that before, Chris?
No, it makes sense to me. Are you now? Are you saying once it transfers title, if the data center doesn't, if they don't catch it and they allow them to keep benefiting from the exemption, that they can go back 3 years and get them? Or are you saying that the seller is now on the hook for the loss of the exemption because they've changed the use? Maybe I'm missing.
Well, the buyer is technically the one that's on the hook, because at the moment that property changes use, the county or the government can go back and assess the difference, or they'll go back 3 years and get the higher taxes at the higher value. Now
Even if it was being properly used as agriculture land for the past 3 years.
Yes. Now, I don't know why that is.
Yeah.
Doesn't it seem unfair? It seems unfair, but I hate tax, right? Why?
Well, government and I hate tax. So yes, that sounds wrong in all sorts of
But
ways.
that's just the way they do it. And I don't know what the logic is. Is the logic is what exactly? I don't know. It's just another way to tax people. So
And why do we tax gifts? Why do we tax anything? It's just a way for the government to get their hand out. I mean, I can concoct a public policy argument. I can say, oh, well, we value Texas agricultural land and we want to preserve the land for generations. And when you go and sell it, we don't take too kindly to that. So we're going to hit the new buyer who's degrading our Texas agriculture land and putting in commercial businesses. And we're going to hit them with this tax bill. But it just seems weird. Just if that's going to be your policy because you don't want land converted from ag land to other commercial use, then just create a tax for that. Create its own tax that says, we are going to tax you based on that. And that sounds effectively like what we're calling it a rollback tax. That is your penalty for converting ag land into commercial land. It's a way that we hate data centers. And so we want to discourage them.
There is an interesting exemption to it. If you are the farmer with the big bunch of cornfields and you want to build a house out there, when you convert your homestead property, that there's no recapture there. It favors that kind of thing. So as far as who pays it is negotiable. You usually see it negotiated in contracts, real estate sales contracts, but technically the buyer is the one that gets stuck with it. So good stuff to know about. Maybe it's a good educational topic for some of our lawyers, because it is sort of an obscure thing that came up in my.
Does this happen in every case? If you're purchasing land and converting it from agricultural land, does this apply in every case?
Okay, every case, yeah. I mean, unless you're gonna use it for agricultural land, you continue use. Well, you'll see. I used to look at.
It really is interesting, because the purpose of the ag exemption is to encourage people to use land for agriculture. You clearly did it for the years of 23, 24, and 25 when you received that exemption. But yeah, it's just a way of making up a number to tax people.
I mean, it is what it is. We just, you're gonna pay taxes and die, I guess. So, all right. That brings our show to a close. I've been your host, Phil Silberman. Chris Hill has been my co-host today. Like us, follow us, review us wherever you get your podcasts. And as a reminder, nothing in this show is to be considered legal advice, and this has all been for entertainment purposes only. If you have a legal question, email us at info@silblawfirm.com and tell us you want it publicly answered in the podcast. Everybody have a great rest of your Friday and weekend.